22 CR 3597, State of Texas versus Chardonnay Leanne Lockhart. Can I have parties announced for the record for the state? Defense.
Andrew Fred, Ms. Lockhart.
Are you Ms. Lockhart?
Yes.
Right. Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Lockhart, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
I am a female. You keep saying, yes, sir.
No, I said yes, Your Honor.
No, you said, yes, sir.
I said yes, Your Honor.
I would
Okay.
say I heard yes, Your Honor, as well, Judge.
Okay. All right. Are you proceeding on the,
One moment.
are you proceeding on the indictment as presented?
Judge, we're gonna go with the lesser included offense of attempted arson, recklessly causing damage.
Okay. Any objection?
No objection.
All right, I'm going to show you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
All right. Oh, you're right. She did say yes, Your Honor. I don't know why it sounded like sir. My allergies are really, I apologize. My allergies are really acting up today.
And Judge, no, I whispered to her that she needs to speak up and not see it. So yeah, no.
Okay, that's okay.
Thank you, Your Honor.
Because sometimes people always say that and I'm like, all right. Did you understand the state is proceeding on the
Notice how sharp the judge is here. She immediately catches a clerical mistake that could change the entire charge classification. What was listed as a state jail felony should actually be a Class A misdemeanor. That single correction can mean the difference between months in county jail and years in state custody. This is a crucial example of how attention to legal detail protects defendants from unnecessary sentencing errors. And credit to the defense, they step up and clarify fast. It's moments like these that remind us how precise and human the courtroom process really is.
need to redo this piece of paperwork.
Sure.
And I would suggest that you use the felony paperwork. That way you can write it in because otherwise I don't have knowledge that she knows that it's a Class A because that's not how it's listed.
That first paragraph I wrote A right next to it. That's my handwriting. First page, Judge, it says range of punishment and it listed up to $4,000 fine up to a year in jail.
Oh, okay. You are correct. Look at
Every
this.
once in a while, Judge.
Corrections are happening. I appreciate it.
I hate to correct you, Your Honor.
That's no. Here's the thing. I always tell people,
Sounds good.
make sure that if I'm saying something that's incorrect, to let me know. Okay.
That's what we did there.
All right. So this is what I'm going to need you all to do, though.
Yes,
I
Judge.
need her to initial it so I know that she knows because all of this is state jail felony paperwork. That's why I say
Okay.
state jail.
Sorry about that, Judge. I saw that. I thought about using the other paperwork, but I didn't know if that was probably the better way. Or from now on, I'll probably try and do that.
Okay. Because all this paperwork is state jail felony paperwork.
I tried crossing out, it was the felony, the discussion about the felony, the felony in possession of a firearm. And I thought I caught everything else. I think I changed everything to reflect.
Yeah, we
Okay.
erased all of the stuff about the firearm possession because that doesn't apply because it's not a felony.
Okay, let me carefully read through the paperwork. Just give me a moment to make sure that everything is the way it should be. As arson as a Class A misdemeanor, the range of punishment for that offense is up to $4,000 fine and up to a year in Nevada County Jail. Do you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court doesn't have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
It's to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Sure.
Anything you wish to say on behalf of your client?
That's the follow the mark.
All right, Ms. Lockhart, if you're released from custody, do you have a place to live?
Yes, Your Honor.
Where?
738 North.
No, I'm sorry, don't say the address,
Oh,
but who will you be living with?
I apologize. It's a property my father had bought.
Sorry, what?
I'll be living by myself.
Well, whose property is it?
My father.
Why were you not living with your father before? During this incident?
No, it's because I'm 30 years old.
Well, no, here's the thing. I'm reading this and it appears, rightly or wrongly, the way I'm reading it, it appears that you were homeless. It says that you started this fire because you were trying to dry a blanket. So I'm wondering why you were not living. Well, no, that's what they say you told them. It's in the police report. So I'm trying to figure out, why were you homeless and why would your father let you live with him now?
This part gets emotional fast. The judge isn't just looking at a case file, he's trying to understand why Chardonnay was living without stable housing, pregnant, and facing serious charges. When she hesitates to explain, you can almost feel the tension rise in the courtroom. The judge's tone shifts from patient to firm, demanding honesty. It's not just about punishment, it's about accountability and reality. Question for you. Do you think the judge's tough approach here is fair, or should he have shown more compassion considering her situation?
Police report. Basically, it's implying that you were homeless because it said there were clothing and other items, and that you lit this fire because you told them you were trying to dry your blanket. So this is what you stipulated to. I didn't force anybody to stipulate to it. That's what's in the police report. So why were you homeless if now you can live with your father?
I wasn't at home, but I was not homeless.
So why were you living in this field or wherever it was with your items?
I have no idea. I don't know how to answer that.
All right, so why is she wearing yellow today?
I'm pregnant.
Okay, I just wanted to hear it. And how far along?
Like 21, 22 weeks now.
Okay.
Judge, I didn't mean to be presumptuous, but I have been in this court once or twice before. I did tell her she was going to be taking a parenting class, which was theoretically outside, but she understands she's going to take the parenting class going forward, because that's going to be her.
All right, and is she on medications at the jail?
Yes, Judge. She was not on her medication at the time. Now she is on her medication. She's frankly alive. She's definitely competent at this point in time. At the time, she was not being rational, but at this time, she is going to be successful going forward. There is the part about the mental MIC caseload and her being interviewed for that. I believe that would be necessary. And she understands that being med compliant is going to be a part of that as well.
All right, do you have any other children?
Yes, I do.
How many?
2.
And where are they?
Out of town with my family.
And what are their ages?
11.
They're both 11, twins?
Mhm.
That's either yes or no.
Yes.
All right, this is what, is there anything else from either side? Do you know if she's receiving SSI now?
I don't know.
All right, I'm going to sentence you to 2 years deferred adjudication. I'm going to want felony drug court referral. They should be able to do it because it's 2 years. And I'm going to want a MIC evaluation. Those are to take place while in custody. And then I'm going to want a referral. If she's not approved to MIC, I want a referral to Center for Healthcare Services, parenting classes. Take in consideration County Court Cause number 634806. 80 hours of community service restitution. Once she completes parenting, that will be satisfied. Regular reporting by Zoom or in person. Regular UAs. And I'm going to want a TAP evaluation in custody as well. If TAP recommends inpatient treatment, we'll start her with intensive outpatient treatment. And I'm gonna want field visits one time per month until further notice. Probation will do proof of employment within 30 days of release, or proof of SSI within 30 days. There's to be no employment as a home health care provider or with minors. And I'm sorry, instead of the regular UA's probation, I'm gonna want the UA hotline with testing at least once a week. Probation, is there anything else she needs?
No, Your Honor.
Is there anything else you need from the court to be successful?
No, Your Honor.
Counsel, do you think there's any?
In the end, Judge Simpson hands down a deferred adjudication, a chance for rehabilitation rather than immediate punishment. With community service, parenting classes, drug evaluations, and mental health treatment, the focus shifts from guilt to rebuilding. What's especially powerful is the judge's decision to recommend mental health court, which could completely clear her record if she completes the program successfully. It's a moment of accountability mixed with opportunity, justice with a second chance. If you found this case as powerful as we did, don't forget to comment your thoughts below. Should she get another chance? And subscribe for more jaw-dropping courtroom breakdowns just like this one.
All right, we can go off the record. Was she not approved for mental health court?
Honestly, can't tell you off the top of my head, Judge. Since she's been in custody this time, we've conferred with the DA, and this was the attempt. She's got quite a bit of time. So this is our agreement that we reached.
All right.
She was approved. I know that she's being evaluated for mental at the MIC caseload, being that it's a misdemeanor, but mental health court, I don't think that was the approach because there wasn't an option to be a misdemeanor until we talked about the last week.
All right, probation, can you also do a referral to the mental health court? And see if they'll accept her. My understanding, mental health court, it's sort of like PTD. So if they accept her and she completes it, then this will be as though it never happened. So counsel, if they accept her in PTD and you all want to come back and ask for a motion for a new trial or withdraw her plea, then the court will consider that.
That's what I was thinking ahead, Judge. That's why my brain was going I don't know if it looked like I was rolling my eyes. Does that mean that she wants? Yes. Okay.
All
I'll
right.
explain that.
So,
Thank
LaShawn,
you.
if you can, you're welcome. LaShawn, if you can make sure she's referred to mental health court and tell them that even though she's entered a plea here, if they are willing to accept her, defense is going to file a motion for new trial and the court will grant it. All right. Thank you. You're welcome. Have a great day.
And I'll explain in a second what she's doing and really helping her out.
All right. And they'll put you back in the box so probation can speak with you. Okay.
Yes, ma'am.
All right.
Thank you.